appearing for the respondent IOC, which is not objected by the counsel appearing for the petitioner, let the matter be listed after 2 weeks. Let the matter be listed on 15th. 15th, is 15th of May.
It is the Lordship. Lordship, I'd like to mention item number 11 and 12. Lordship, may kindly grant me some more time to file my affidavit.
You haven't filed affidavit in reply. Are you going to file? Okay. MS so-and-so, the learned counsel, appearing for the petitioner, submits that she wishes to file an affidavit in reply in the instant case and prays for 2 weeks time. 2 weeks time is allowed. Let the matter be listed after 2 weeks. 11 and 12.
It is your lordship, my lord. I beg to mention item 47. I am for the contempt petitioner, my lord. The contempt note has filed an affidavit in opposition, my lord. I have to file an affidavit in reply, my lord. So, my lord, 2 weeks time may be granted, my lord.
Okay, 2 weeks time is on the prayer of the learned counsel appearing for the petitioner. Let the matter be listed after 2 weeks.
Maybe. But my next one is item number 13, 1-3, Lordship.
13,
13, Lordship. But
Yes.
we filed a reply.
you filed a reply? Or you are going to file a reply?
Lordship, I am going to file reply, Lordship.
Okay, on the prayer of the learned counsel, you are appearing for the petitioner, let the matter be listed after 2 weeks. In the meantime, the learned counsel will file the affidavit in reply.
May it please the lordship.
Why haven't taken the steps till now?
It was left out inadvertently. Unintentionally, it was left out.
Unintentionally, 2025 matter, you haven't taken steps, notice was issued.
Last Friday, we took the step.
You have taken the steps?
Yes.
Okay. Learned counsel appearing for the petitioner submits that he has already taken steps in the instant case. Let the matter be listed. Steps for service of notice in the instant case. Let the matter be listed after 3 weeks. After 4 weeks.
Like.
2, 3, and 4.
My lord, steps were taken. This matter has come up for. not
You have
taken-
taken the steps, but
Yes, my lord.
office note says it was
Yes,
not.
my lord, but subsequently on 24, these are the,
After 23rd, you have taken the steps.
and respondent number 5 is based in Mumbai. So, my lord, some time may be given for them to come and appear.
Okay. I heard Mr. R. Sharma, the learned senior counsel, assisted by so-and-so. He submits that steps have been taken for service of notice on the respondents. When did you take the steps?
24th.
24th of April, 24th of April, full stop. MS M. Kotoki, R. Kotoki appears for 2, 3, and 4. Standing counsel for? Okay. You write appears for 2, 3, and 4, the BPL, Bongaigaon Refinery Limited, BRL. BRL. Okay. BRPL, okay. Mr. S.S. Roy, the learned CGC appears for respondent number 1. Let the matter be listed after 4 weeks for orders.
My lord, interim orders passed earlier. sir.
After 3 weeks for orders. The petitioner will serve extra copies, request number of extra copies to the counsel appearing for the respondent. Let the matter be listed after 4 weeks.
My lord, and interim orders passed earlier.
Interim orders so passed earlier shall continue till the next date of listing. It will be listed in order column because let's see what about 5.
My lord. Okay.
May I have for imprisonment of the petitioner. Page number.
You have filed an affidavit. Okay.
my lord, already we have filed this matter was last listed on 27/2, like this. Till that he has not filed any objections. I am that necessary party, lordship. Kindly peruse
You
the.
file an
paper.
affidavit, I mean, you file an objection, whatever, I mean, you file an affidavit. Last time also it took time.
My lord. I am not necessary party or always, on the basis of the application filed by the.
Okay, let them file their objection, they
My lord,
want to file,
kindly
wishes
fix
to
the
file.
date, my lord.
If wishes to, 2 weeks, after 2 weeks,
My
we'll.
lord, kindly fix the date, my lord.
You are Mr.
R. Gurva.
R. Borova, the learned counsel appearing for the applicant. This is in IA, huh? For the applicant. Also heard Mr. A. Atria, the learned counsel appearing for the respondent. Let it, the order be passed. Don't interrupt in between. Mr. So-and-so appears for the corporation, on behalf of the corporation department. Respondent numbers 2, 3, and 5. Mr. Atria submits that he would like to file an objection in the IA. Therefore, prays for 2 weeks' time. Prayer is allowed. Let the matter be listed after 2 weeks. Interim order so passed earlier shall continue.
Praise for
I-
that
In
date,
in the main petition,
My lord, praise
the
for the
main
date, my
petition,
lord.
WBC. interim order.
Praise for the date, my lord.
Okay, let the matter be listed on 14th. 14th of May. 14th of May.
Lordship, the petitioner is
And they're disputing the amount,
no dispute. There's absolutely no dispute.
but they have filed an affidavit saying that this is a disputed amount.
No, Lordship, they never said that.
What did they say?
They say that they have paid this much, this amount they have paid.
Hmm.
They got 1,35,37 lakhs, out
Hmm.
of which they paid a certain, about 1 crore, just give Lordship. They paid 1 crore 5 lakhs.
What was the amount?
Total claim amount was 1 crore
37 lakhs,
37 lakhs. Lordship, that is
85.
that is not the point, Lordship.
Ah,
Point is what has happened. It's undisputed that they had to pay us money. That is 1 crore 37 lakhs, out of which they paid us 1 crore 5 lakhs.
so 8 lakhs they wanted to pay, but it didn't, I mean, they are
We
country.
did- We did not take that 8
Hmm,
lakhs. We did not take the 8 lakhs. Balance 32 lakhs, they have remained on last occasion. They said it was for tax, etc., etc. But tax, it would be reflected into my account, which has not been reflected. And they are entitled to charge service charge of 7 lakhs and odd, and a GST at that point of time, which is 4%. So this is far beyond that. But that's that apart. Lordship, what has happened? I am a small scale industry. I am registered under the MSMED Act. I have a ME Part 2 registration. Those facts are not disputed. They have not disputed those facts either. Now, what happened if I am a MSMED, I have certain protections
Benefits and privileges, yes.
under the Act.
Hmm.
And one of the protection is that you will pay my bills within 15 days. 45 days, sorry. And this is notwithstanding any agreement on any other law in force. That is the overriding effect. That is primarily, you cannot have any agreement or anything contrary to this. 15, 16, 17, these are the very specific sections.
Provided the amount is not disputed or whatever.
We are not disputing the
Hmm,
amount.
hmm.
They have retained some amount. So question is whether they are entitled to retain. That would come later. That apart, we completed our work on 3/2/2017. And status report by them is on 25/8/2017. Lordship, status report, I have annexed it also, which is at page 24. So which says yes to everything. So everything is completely is done.
Page 24, Annexure 7.
Annexure 7. That is
Yes.
the status report which has been given by the executive engineer,
Yes.
not by me. Which
Hmm,
says
I
everything is
don't,
completed in all respects. So within 15 days, they are supposed to give us the money, the 45 days, sorry. So it should have been paid on 10th October 2017. 45 days expire on 10th October 2017. But money was released, certain portion of the money was released on 25/5/2018.
Where is that provision that it has to be paid within 45 days?
That is the Act,
That is in the Act,
Section 15 of the.
the MSCB Act. Only.
Liability of, if I may read,
Yes, one second. MSCB Act.
if I may read very slowly.
Yes, yes, yes.
When any, section
The
15,
section
section 15,
15, yes.
a liability of the buyer to make payment.
Hmm.
Where any supplier supplies any goods or renders any service to any buyer,
Hmm.
the buyer shall make payment therefor on or before the date agreed upon between him and the supplier in writing, or where there is no agreement, it is on in behalf before the appointed date. Proviso that in no case the period agreed upon between the supplier and the buyer in writing shall exceed 45 days from the date of acceptance or from the date of deemed acceptance. Then 16, Lordship. Date from which and the rate at which interest is payable. Where any buyer fails to make payment of any amount to the supplier or as required under section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any law for the time being in force, be liable to pay compound interest with monthly rest to the supplier on the amount from the appointed date, or as the case may be, from the date immediately following the date agreed upon, at 3 times of the bank rate notified by the Reserve Bank.
That
So-
means, what will be the thing?
After 45 days
Hmm.
from the date of supply, or I would take status report at it, because supply was much earlier. Even I assume status report is the date. You should have paid in October 2017, but you paid it in sometime in May 2018. So I'm entitled to interest in that. And now, as far as the deduction is concerned, which they have deducted, that 32 lakhs, as per the contract which I have annexed, Lordship will find at page 80. That is the agreement which they entered with me. The Assam Housing Board will deduct SD money at the rate of 10% agency service charge. 16 into this much, they've calculated with 7 lakhs this from the bills together with other standard deductions like that, labor cess, forest royalty, as per the rule of the government of 8%. Now they can take service charge plus VAT. Now what is VAT? They will have to specify. They cannot just pocket 35 lakhs and say, take 8 lakhs. That they cannot do. They have to specifically say on what count they withheld this amount. And that is one point. Now, what has happened, Lordship, as far as payment of interest under the MFME Act is concerned, this honorable court, the coordinate bench, has passed a detailed decision about the liability that 1516 is mandatory, and they also laid down the way in which the interest to be calculated. And the court had said that you file a claim before the authorities, giving your total, you calculate as per the ratio laid down in this decision, and the authorities will consider. So my simple case here is also, Lordship, no one can deny that the interest is payable, that I will make a claim in terms of their judgment. I'll just give a copy of the judgment to your Lordship, and let them consider and decide and make the payment. It's a long judgment, Lordship. I will not take your Lordship to the entire judgment. Lordship will come to paragraph 79.
Paragraph 79.
79. Others are the facts of those cases.
Yes.
Have you opined that it is very pertinent to take note of section 15 and 16 of the Act, which are recorded hereunder, reproduced hereunder. The court quotes that a perusal of the above quoted 18, a perusal of the above quoted section 15 of the Act statutorily imposes an obligation upon the buyer to make payment on or before the date agreed between the buyer and the supplier in writing, or where there is no such agreement in behalf before the appointed date. The term appointed date has been defined as in section 2B of the Act, meaning the day following immediately after the expiry of the period of 15 days from the date of acceptance or the date of deemed acceptance of the goods or any service by a buyer from a supplier. Section 2B is being reproduced here. There is reproduced. The provision of section 15 further stipulates that under no circumstances the period agreed upon between the supplier and the buyer in writing, except 45 days from the date of acceptance or the date deemed to have accepted. The proviso is relevant, taking into account that irrespective of any agreement contract between the parties, the statutory injunction holds the field and thereby confines the period not to exceed 45 days from the date of acceptance or date of deemed acceptance. Now, take note of this code, that section 16. There are also two aspects in section 16. First, that it is to be calculated from the appointed date, and secondly, the liability to pay compound interest with monthly rest. In this regard, the court finds relevant to take note of the judgment of learned Calcutta High Court, and this is reported in this, wherein the learned Calcutta High Court explained the very concept of how the calculation is to be made. Now, how the calculation is to be made is quoted here below. Then Lordship will come to paragraph 83. It is the opinion of the court that that the interpretation given to section 16 of the Act by the learned Calcutta High Court, as stated herein above, it lucidly laid down the principle for calculation of interest, and this court agrees to do the same. The above analysis show that the petitioners have the pension people would be entitled to benefit under section 1517 of the Act. It may also be it would also be interest component on the admitted dues has to be worked out as per the principles laid down as discussed above. The matter before the court only refers to the work orders and to the date on which questions then Lordship. This is I have not. So finally, the court has directed us, Lordship, at paragraph the court at last paragraph. Last but one paragraph at clause 10 towards the bottom. Because the court has duly noted that during the pendency of writ petition, payments were made to the petitioner. In view of the settled principle of the law laid down by the Constitutional Bench of the Supreme Court in case of Gurpreet Singh Supra, the apportionment of such amount already paid has been first applied to the interest, and then if any amount remains towards the cost, finally towards the principal amount. It is the opinion of the court that the payments made to the respondent during the pendency of the writ petition shall therefore be first applied to the interest payable to the petitioner. Thereafter, if any amount remains, it shall be applied towards cost and thereafter to the principal amount. As the three writ petitions, the court observed that the three writ petitions would be entitled to interest in terms of section 16 of the Act. Therefore, while computing the entitlement of the petitioners, the amount is to be paid during the pendency of the writ petition shall be first adjusted towards liquidation of the interest amount payable to the petitioner. After exhaustion of the interest payment, if any amount remains, then it shall be applied for liquidation of the cost and debt towards principal. The court further observes and directs that during the period from the date of submission of the claim,
So in your case also, the amount was paid during the pendency?
yes,
During the pendency, not before that.
during the
That
if it's not, there's delay. So, Lordship, I want a simple direction in terms of the guidelines laid down in this matter. I may file my claim before, and the court has also before the authorities, and the court has also given that within 90 days they will of the claims, the respondents will look into the matter.
So you file your calculation
I'll file
with
my-
a representation.
Yes.
Then they will have to consider this as per the guidelines laid down by this court, by this, in this judgment.
That's a small direction.
Mm, mm.
So with that, the matter can be disposed.
Yes, yes.
Nothing, no finding as such I want,
Mm.
only that.
Have you seen this case? You are aware of this case? Whatever the guidelines has been laid down in this case, how it is to be calculated, how it is to be given. See, facts are almost similar kind of thing. That during there was some services given. So you have deducted some amount, rightly or wrongly, that's up to you. Now thing is that during the penalty, some amount has been paid and certain amounts has to be paid. Now what they are saying that they will give you a calculation with a representation, then you'll have to dispose of this application.
For filing this, we have released that. Now, let's say, my landed claim is not disputed, remaining amount is 13,78,000.
No, remaining amount fine. What about the interest part?
It's not MSME, it's not MSME per day. It is contractor and the government of Assam.
Correct.
At that moment of time, MSME.
Government, if government is an employer,
Even though, Lordship, even though it is a civil nature, Lordship, even though we consider the MSME at 2.6, then as per section 18 of that MSME Act, reference to micro and small enterprises and specification council. They should have to approve the before the council.
but that's a different aspect. I mean, that I am aware of it. It has to go to the MSAB, council is there, council will send it to arbitration, all these things, we are aware of this. Only thing is that, see, now a settled judgment has come, wherein it has been laid down that how it has to be paid, how it is not to be paid. So you need to consider it. I mean, after that, after your consideration, if they feel aggrieved, then they.
They will call by us.
Hmm.
Come forward to our- Even though they did not want to discuss that.
So where is the stand that you have paid earlier to prior to filing of this writ petition?
File, the initial payment itself is late. Initial payment itself is late. I'll be entitled to interest nevertheless.
Now, as per that calculation, Lordship,
Not
No, you show me the stand, yes, stand.
Where's the interest calculated?
They have written to us, Lordship.
Now, where is your affidavit? Wherein what stand you have taken? You just show me that. One second, 1 second. Madam, in your case, why section 18 will not be applicable?
Lordship, section 18 would come if there's a dispute. The Honorable Court also considered that.
There is a dispute in calculation of the interest.
That interest was never calculated. Interest was never calculated. And the Honorable Court also in this branch has observed, they had taken this objection regarding
So your case is that there is no dispute about the amount.
And they have also not calculated. There's no dispute. So calculation has to be done. So my humble submission is, let me produce. If a dispute arises, then we'll go to section 18. Because if Lordship looks at section 18.
Yes, I have seen
It's
this.
very clear there has to be a dispute.
Yes, so you are saying that there is no dispute because they have not calculated as yet.
They have not calculated. I have not calculated. I have not given them my calculator. I have only made them request to make payment of him. In fact, at one.
So, Mr. Counsel, so what is the problem in like sending it back?
We have several times we have called you.
We'll go now.
They did not come forward to our office.
Because of the pendency of the matter.
Maybe the case was pending.
After the court also.
Now, so that's why now the effort will be made by them. So they will give a representation along with their calculation. Then you'll have to sit down. Both of you have to sit down. And if it is fine, you'll have to pay. Or if you think that there is some dispute, then there is the different ways to do it. Settle it. They'll do it. So in that terms, I'll pass the order.
Obliged, Lord.
There will be discussion among us.
When they file a representation, obviously there will be a negotiation, discussions, whatever. And if there is something settled, then it's well and good. If it is not settled, then you'll have to pass an order or whatever, because they will file a calculation sheet. Then you'll have to dispute the amount. If we dispute the amount, then they'll have a different recourse. They'll go there. So in that terms, I'll pass the order. Okay, I'm not passing the order now. That's fine now. Now she's saying that she wants to, she wants to approach.
We'll file a claim petition.
You file a representation or claim petition, whatever,
petition,
whatever name is there, I
Ah,
mean, that is
And we'll
different thing.
dispose of, the lordship will give a time-bound period to.
I'll give a time period.
It's 30 lakhs amount. Now became lordship.
No,
One
whatever,
crore
no,
50
whatever has done. Now whatever is what, what?
They are claiming, right now they are claiming that 1 crore 54 lakh 76,925 lots. This 30 lakhs amount, 30 lakhs.
So I will find my claim.
So,
Detailed claim because I have to work out what is the paying rate of interest.
and are you obliged to pay whatever then they will claim 10 crores of rupees. Are you obliged to pay? Then
And then lordship, we are bound by the Reserve Bank rate. The
le-
repo rate.
you can give whatever interest rate you think as per the law, then they will decide about this. And you dispose of this within what time? You'll have to pass a speaking order kind of thing. I mean, civil file, they will file a claim petition or whatever. Then you'll have to call them, give a hearing, then decide whatever. Then you pass an order. I mean, if you think that like a matter can be settled, it's well and good. You settle it MCME. So you settle it. And if you think that it cannot be settled, then you'll have to pass an order.
Lordship, 45 days
45 days, fine.
of life.
Money will be paid by you only. They are only your consultant.
Obliged.
We are only executing corridor.
Who is going to pay the money?
PhD.
But
No,
funds should have to release by the.
It is routed through the PhD lordship. It's a NEC fund. Yes, it
Then-
is. Lordship, he has not read the petition. It's a NEC project which is routed by the PhD. PhD has given the approval. They have given the approval. Sanction. The sanction have given by PhD. That is there, they will decide.
But your application will go to housing board only.
And
housing
PhD
board
also.
And that's their internal matter. Let them do
And the
whatever they
PhD
want to do.
also there.
That is your internal matter. I mean, you decide whatever. But
I'll
you,
make both, Lordship. I'll make copies to both.
you may give a copy to them. Then
Absolutely.
let them decide.
I will make to both.
But you principally you will
It is
submit. It has
It
to
has
go
to
to
go
them.
to us.
It has to go to them. So 45 days. 45 days you dispose it of. Fine. You take down their names. Take down their names.
Obliged.
Then I'll pass the order. itu mung di MSCB account
In this case, a affidavit has been filed, madam. Reply has to be filed.
you are going to
By-
file reply.
Yes. Affidavit is filed by the private respondent, madam. Last Friday, madam.
It's not on record. Mr. Sharma is appearing for whom? You have been newly engaged. Okay, heard Mr. S. Count, the learned counsel appearing for the petitioner. Also heard Mr. S. Sharma, the learned counsel appearing for respondent number 5. Mr. Sharma submits that he has an affidavit in opposition on behalf of respondent number 5 has already been filed. However, the same is not on record. Mr. Count submits that he has received a copy of the affidavit in opposition and would like to file a reply within a short time. Therefore, he prays for some time.
The 2 weeks, madam.
Let the matter be listed after 2 weeks. Mr. Talukdar appearing. Mrs. G. Bodley appearing for? Mr. G. Bodley appears for respondent 124. You have 124. Have you filed any affidavit? You have already filed an affidavit. Okay. Let the matter be listed after 3 weeks.
I'll serve, madam.
Yes, I will give it.
Yes,
to
I'll
you.
serve.
After 3 weeks, huh?
May I please, Your Lordship, kindly pass over the matter for timing.
Affidavit, you haven't filed any affidavit. You filed affidavit. Are you going to file any reply to this affidavit?
We don't have a copy of this affidavit.
They have filed on 25/3. Are you going to file a reply to this?
23. Lordship, we have.
Yes, yes.
Hmm?
Sorry, Lordship, we have.
So why don't you check? Your name?
JSC, Lordship, we would like to file a reply.
Heard Mr. So-and-so, the learned counsel appearing for the petitioner, also heard Mr. N. Goswami, the learned counsel appearing for, learned government advocate appearing for. Response number 2. 2 and 3, G. Hazarika for 1. Roy is appearing? No. The learned counsel appearing for the petitioner submits that he has received a copy of the affidavit in opposition filed by the respondent, and he would like to file a reply. 2 weeks time granted, let the matter be listed after 2 weeks.
Obliged.
Now kindly first take up the item number 9, madam. Here I am, item number 9, madam. 58 is the impugn order, madam. '59, madam.
One second, one second. Madam Bhuya is appearing for S1 or 2? S1 number 2. Okay.
Page 59, madam.
Hmm?
59 is the impugn.
Page 59. Yes.
This has been issued by the chairman of Musalpur Municipal Court, madam.
Hmm. So you are saying he doesn't have power? Hmm?
Doesn't come under the municipal act also.
Hmm?
But property does not comes under municipality act. There are government property, but this comes under the,
You run what?
my name is Lokeswar Taluka.
Hmm. So you have, allegation is that you have encroached the land, veterinary land. Hmm? Hmm. No, this has been issued by you. How can you issue this?
Municipal board, madam.
Municipal board, whether municipal board has any power to issue this kind of notice? It doesn't look like municipal board has power to evict somebody.
The municipal board is concerned.
What stand you have taken in your affidavit?
They say by it is a government khas members.
Hmm.
Para 9, madam. Page 62.
But you have not responded to that, I mean, that was the main aspect. Hmm. Yes. But you have been granted time and you have filed an affidavit also. See, that was the, I mean, if you see 27 to order, that has been clarified by the coordinate bench that after hearing I mean, he's saying that like, may not be a power. So that aspect we have not taken into, I mean, taken into account. You'll have to show that if you have a power, otherwise this will go. So what is?
It's a conformity in Solpur Municipal Board. We have taken
The Mushalpur board, I'm correct, but it's a Kokrajhar district, na? Kokrajhar, the BTC will be having power overall.
the BTC.
So BT is a BTC subject. But that you'll have to take some, I mean, because BTC will have that subject matter is within the BTC. So though they are a statutory body, but like that power is with BTC. So you'll have to take a stand that whether you can do it or not. We'll post it, like let her take instructions. I mean, you have not clarified anything in this affidavit. So that should have been clarified otherwise. So we'll post it day after tomorrow. Day after tomorrow is fine. No, coming week, it will be difficult. Okay, I mean, heard Mr. S. Botakoda, learned counsel for the petitioner, also heard MSB Bhuya, the learned senior counsel, appearing for BTC, right? Appearing for BTC. MS Bhuya, praised for some time. Prayer is not objected by the learned counsel for the petitioner. Let the matter be listed after a week. After a week.
The intent order may be.
Interim order so passed earlier shall continue till the next day released. After a week, so it will come. Okay, then we'll give a fixed date. Let the matter be listed on 7th of May. We'll have 6th, 5th. 12th, okay. 12th of May. You find out you don't have any power. It looks like you don't have any power. You don't have power, then it will go. I mean, I think ideally it could have been disposed of today only. Correct. I mean, there is nothing keeping pending. It will go otherwise. You just find out where, I mean, on what provision they have, issued this notice. I mean, if they cannot give you, and I don't think they would be able to give you. So, I mean, there is no point keeping this matter pending. Day after tomorrow, we just talk to them. Okay, let the matter be listed in day after tomorrow. Yes.
Item 10, my lord.
Yes.
Here the case is, my lord, the petitioner, my lord, he is the investor under the Sahara group of companies, my lord.
One second.
What happened? The asset of the company was taken over by SEBI. Subsequently, my lord, at the direction of.
Taken over by whom?
My lord,
Taken over by whom?
now, the issue is not with SEBI, my lord. The issue is, my lord, against the, my lord, Central Register of Property Societies. That comes under the Ministry of Home Affairs, my lord. Here, my lord, at the direction of the, my lord, the Honorable Supreme Court passed the direction on 29th of March 2023. Directing the, my lord, Central Register of Property Societies to release the money of the depositors' money of the Sahara group of.
See, okay, Sahara Group, who is appearing for Sahara Group? There is no, I mean, is there anybody there in Sahara Group? The issue is that he has invested some money there and they have got bankrupt now. Now he is saying that there is a Supreme Court case wherein a direction has been given to.
SEBI has released, initially they have released 5,000 crores.
That has been paid to some people.
Yes, but
Hmm.
the amount of the delegate investors.
Then now.
No, my lord, I am explaining the details, my lord. SEBI took over the asset of the Sahara group of companies. Now the Honorable Supreme Court directed the SEBI to release the money to the, my lord, Central Register of Property Society, and Central Register of Property Society to release the money to the SEBI. Now at the direction of the Honorable Supreme Court, after this order of the Honorable Supreme Court, I made central register of cooperative society. Now the central register of the cooperative society is the main party.
Hmm?
Central register of cooperative society
Hmm.
is the main party here.
Hmm.
That party will release the money, not Shahara, nor even the SEBI money.
Sahara has been taken away. Okay, Sahara has been taken away.
It's taken away. Even the SEBI has filed their affidavit. The extent of the SEBI is very clear that as per direction of the Honorable Supreme Court, we have released the money.
SEBI has released the amount.
Release the amount to
Hmm.
amount in the amount that was directed by the Honorable Supreme Court,
Hmm.
5,000 crore, in favor of the
Hmm.
central register of cooperative societies.
Hmm.
Now the central register of cooperative societies will release the money of the investor
Hmm.
on case wise. Now, after this order, I made communication with the central register of cooperative by a representation that was considered. Not even no response was made by the department. Then I approached this court. That in terms of the direction of the Honorable Supreme Court, they invested money of the petitioners and petitioners' family members that amount.
Yeah, got it. I understood it. Now, who is appearing for this thing? Cooperative society is this? Then what is your stand? Hmm. Hmm.
Verification.
Hmm.
After it is found genuine,
Hmm.
the money has been returned to the investors
Hmm.
and already in auction, more than 7,000 crores has been disbursed to the genuine investors.
Hmm.
Auction, I only request to this order.
Well, in that case, that is an analogous case with this writ petition. In that case also, I was the counsel of the petitioner. That case was disposed of directing the petitioner to submit to online portal.
Hmm.
As per direction of this court, I made I have applied for online portal,
Hmm.
and still now it is more than 6 months. The money they should have
They are saying they are phase wise, they are doing it.
doing it.
Auction,
Hmm.
already the time extended first of December 2026.
Now,
The time is still there.
That they have to do it.
Hmm.
no, my lord, as per the online portal, the scheme, my lord, they should make the payment within 45 days from the date of application in the online portal.
Now, where is the scheme? 45 days from where you are saying?
Well, that since that file is not before lordship, that is a different.
No, no, understood. Then from where you are saying that 45 days is the limit?
That when my lord, online application is made, my lord,
Hmm.
for that portal, my lord, it automatically generated. The scheme is automatically generated. Even they are very much aware, my lord.
So 45 days you are supposed to dispose it of.
Dispose it of.
Also, there are, after it is found genuine.
Genuine.
Hmm.
Now, all these certificates were uploaded
You know, once he uploads his application, how much time you take usually?
for online portal.
There has to be some time limit. So what is the time limit you have?
My lord, that file I have not brought it because
Actually, also in that case, was it is already disposed of.
dispose of.
And in this case, I was also appearing your lordship, but the petition has been, copy of the petition has been not been served to
Which petition?
this case.
Firstly. Secondly, my lord, their online scheme is that, my lord, only up to 5 lakh rupees can be, my lord, submitted for online portal. Now here is a case of 78 lakh rupees,
Only 5 lakhs.
only up to 5 lakh. Maximum limit is up to 5 lakh.
Hmm.
Starting from 10,000.
Then how could you manage to upload them if it is only 5 lakhs?
No, in the earlier case, it was only 1,30,000. So that was possible.
No, no, no. In this case, whether you have
In this
filed
case,
online.
it is possible. It is in this case, my lord, it is not possible to make through online portal to submit the
Correct.
through online portal.
Hmm,
by
hmm,
here.
hmm.
Now the only option is all the documents are genuine documents. I have the original copies of the documents. I will submit the original copies to the department, Central Register of Property. They will verify the documents. They will find find out the genuineness of the documents, and if they find the genuineness, they will pay the money.
Copy of the petition shall be served to me so that I can communicate with my department.
Why haven't they given him copy?
Earlier, copy was served. my lord, to the
Copy must have been given. I mean, it's pending for quite some time.
Then lordship, but
Huh.
it's in 2025, sir.
Then why haven't you taken a copy from him earlier? Hmm? Then why haven't you given him?
Later I asked for the soft copy also.
Well,
That
at-
was also suffice.
At the time of filing of the writ petition, obviously, my lord,
Correct, like there was a different counsel, EOA. I mean, you'll have to look for your own interest. So what is to be done? Should we dispose of in this line?
That lordship, there is 5 lakhs.
No, he's saying that there is no dispute that there is an authority which is going to release it. The authority is you. Correct? Authority is you. You just need to only verify the correctness of the claim. And after verification of the correctness of the claim, if you reject it or approve it, that's up to you, your authority. Correct, that they will do. And another problem is that it cannot be uploaded, he's saying, because the threshold is 5 lakhs. So if it is 5 lakhs, he cannot do it because his claim is 78 lakhs. So he is asking that, like, since he cannot upload it online, so it should be considered, otherwise, physically.
There is lack of manpower.
No, then you tell me how to do it, resolve it. No, I mean, you should have taken instructions. No, when was it listed earlier? See, 15/9/2025, who is DZS? Your DZS. You ask for affidavit in, see, don't give this kind of submissions. You ask for 2 weeks time to file affidavit in opposition in 2025. With what? With a copy. I mean, you come, then, I mean, so much of time has passed.
Under that impression, Lordship, I was.
And Malud, there is another difficulty also. Say suppose if a person makes.
And you have not said anything about the copy also.
Lordship, that was a verbal communication. That was a verbal communication. That being recorded it.
Okay, yes, sir, we may copy today. I will fix it on the day after tomorrow. By this time, you talk to them what is to be done. Okay, heard Mr. M.A. Islam, the learned counsel for the petitioner. Also heard Mr. B.J. Das, learned counsel appearing for respondent 1 and 2. And Mr. B. Chaudhary for respondent senior counsel appearing for respondent number 3. Respondent number 3. And anybody else? Okay. Mr. D.J. Das, the learned counsel appearing for respondent number 1 and 2, submits that he is yet to receive a copy of the writ petition. Full stop. Therefore, he prays for a copy. The same will be served by the counsel appearing for the petitioner during the course of the day. Let the matter be fixed on 29th. No, 29th. On 20. You just ask for, that's only ask for one thing. Find out that if because your portal is threshold is 5 lakhs, you just ask from them what is to be done. Whether captain need not be removed, what is the solution for that? You come up with that, then we'll see what is to be done. Correct. We'll see it. I mean, you ask them what is the, I mean, that much of instruction we can get it by day after tomorrow. Fine. Let the matter be listed on 29th. Because there is no point pending this. Correct. I mean, if you come up with some instruction that, okay, this can be done physically also, then we can dispose it of.
Last time also
Hmm.
physically, that the previous case, there is no mechanism for physical verification.
But now what is the solution? That's what I'm asking. That deal, there has to be some ways to do it. Because 5 lakhs, somebody may be having 1 crore, somebody may be 2 crore, then what they will do in that second. You just find out. You take the instructions, huh? Because we don't want to keep it pending. Hmm.
16.
16, anybody appearing? Yes. Hmm? What I mean, what? What is your name?
A Hussain,
What do you want?
passport time being.
Why? Who is your senior?
J.I. Borbuya.
Huh?
J.I. Borbuya.
Where is he?
He's coming, Malud.
Let the matter be listed after 2 weeks.
Let's
20.
None appeared for the petitioner when the matter was called for. Mr. Roy appearing? let the matter be listed after 4 weeks. None appeared for the petitioner when the matter was called for. Let the matter be listed after 3 weeks.
22. May I please, your lordship? My lord, in this petition,
Yes,
your lordship may kindly peruse page 81, madam. Because the order passed by the learned executive magistrate, madam. This order, my lord, annexure 15, page 81, madam. Order dated, my lord, 21.
then affidavit has been filed. Hmm.
Eight and nine, my lord, 5 have responded, madam. On the earlier occasion, they took time to file their affidavit, madam.
No, they haven't taken time. Time was taken by you. Petitioner side.
Well, then, my lord, my other learned counsel was there, my lord. I was subsequently engaged, my lord.
So you should know about the, what order has been passed.
My lord.
Then how can you say that like, order was, heard Mr. What is your name?
T.U. Laskar, my lord.
T.U.
Laskar.
T.U. Rustam, the learned counsel appearing for the petitioner. Also heard MS. B. Das on behalf of A.M. Ahmed for respondent number 8 and 9. 8 and 9. Mr. Hendik for, J. Hendik for. Are you going to file any affidavit? And MS Mohanta for respondent number 1. Ms. Mohanta for respondent number 1. The learned counsel appearing for 8 and 9 submits that praise for 2 weeks time to file affidavit in the case. Prayer is allowed. Let the matter be listed after
My
2
lord,
weeks.
one thing, my lord. For proper adjudication of the matter, my lord, I have also filed an additional affidavit, my lord. So that may be part of the record I have filed.
That is already there.
My lord,
Affidavit is already there.
my lord, my lord. Obliged. A date may be fixed, my lord, kindly, so that.
3 weeks.
My lord.
After 3 weeks.
My lord.
23.
You are appearing for whom? Has not reached court. He's on legs. Okay, none appeared for the petitioner when the matter was called for. Though MS so and so on behalf of Mr. D. Upamindu Learned Counsel appearing for Health and Family Welfare Department is present. Mr. Nayak is appearing for? House, yes, that's what I've seen. So we'll fix some other time. Mr. P. Nayak, the learned additional advocate general, appears for the health department. PW department, sorry. PW department. Let the matter be listed after 2 weeks.
24. 24.
None appeared for the petitioner when the matter was called for. Let the matter be listed after 2 weeks.
May please your lordship. The petitioners before your lordships are paying for fair compensation of your land.
Praying for what?
Fair compensation,
Hmm?
fair compensation lordship.
Fair compensation?
Compensation for acquisition of land by direct purchase.
Hmm.
Lordship may kindly have a look.
Your land was acquired from where?
From our, from us lordship.
From you, in Sirang district.
Yes, lordship.
For what? For construction of road?
Yes,
Hmm?
construction of road, namely
Hmm.
Chapaguri, Amtega, Bhutan border.
But notice was issued only recently, so let them file affidavit.
Lordship, what I respectfully pray, lordship can dispose it of with the direction to the petitioners
Hmm.
to file their individual representation.
Hmm?
To file their individual representation along with all the documents which were.
No, what they are saying is that, yeah, you have taken their land. Now, why you have not taken the instructions? Hmm?
Keeping it pending, lordship, it will not, it will not help lordship, keeping it pending, because lordship, let them file their representation with all the.
No,
by-
you let them means that you want your representative file.
Yes, lordship. Annexing all the documents, lordship. Individual representation, lordship.
Who is your senior? Hmm? B. Bhuya. BTC. You call her, she was there only. You call her, I mean, you are not a BTC council. But somebody should be there when the matter is there. I mean, learned council was there some time back. Yes. Hmm. Why? But is there any ground of dismissal? Hmm. Hmm. Then again they will come back. I understand that, Mr. Dhar.
We are entitled, lordship, let us file our.
So
representation.
assessment will be done, I mean, by whom? And assessment will be done by the, I mean, there is a market value, there are some
Yes,
ways
yes.
to do it.
Yes.
So they have already done it.
They have done it, but not fair.
You are saying that like, you are aggrieved by that.
Yes.
Let them file an affidavit. It's better. It will be let them come up with their stand. As Mr. Ardhar, the learned counsel appearing for the petitioners, also heard MS so and so, the learned counsel appearing on behalf of MSB Bhuya, the learned standing counsel for BTC. Also heard Mr. P. Nayak, the learned additional advocate general for PWD department. MS so and so appearing for BTC submits that that she is yet to receive the instructions, then prays for 2 weeks time to complete her instructions and file an affidavit, and file an affidavit in the matter. 2 weeks time is granted. Let the matter be listed after 2 weeks.
All right.
May I please look? Well, in this case, my lord, we have, my lord, submitted application praying for, my lord, certificate copy of Van Dyke map, my lord. But till that.
Certificate copy of?
Van Dyke map, my lord.
Hmm.
My lord, which has not been provided, my lord, me without any assigning any reason, my lord. That is why we approached before this court, my lord.
Why do you want this Van Dyke map?
My lord, to, my lord, substantive.
How you are interested in why you are interested in the Van Dyke map?
My lord, in a case, my lord, plaintiff filed a case, my lord, against me, my lord,
Hmm.
regarding, my lord, right title and interest of the land, my lord.
Hmm.
My lord, in that case, my lord, I have to prove my lord, interest from my lord, Van Dyke, my lord. So that
Hmm.
is why, my lord, the Van Dyke map is required, my lord.
Where is your application?
my lord, page my lord 30 and 31, my lord. 30 was my lord given to the joint director, my lord.
Hmm?
Uh,
Page 30,
Page 30, yes, my lord.
30?
This submitted before the
Hmm.
joint director of service, my lord.
Joint Director of Surveys.
Yes. Thereafter, my lord, I have been, my lord, I have been advised, my lord, that you have to come proportional, my lord.
They have not responded to
Then
this.
Thereafter, I have filed, my lord, to the,
One before DC.
yes, my lord.
Let them come back with the instructions. You have filed very recently, not very far.
Yes,
The election was also there.
my lord, a date may be fixed, my lord, so that
No, that is not that. I'm sorry,
after, in the month
Yeah,
of.
the
May,
election was there. You have filed your application later, in the later part of January. Later part of January, right? So let them come up, whatever. Heard Mr.
Yes,
A. Hussain, the learned counsel for the petitioner, also heard Mr. HK Hazarika for respondent number 4, 5 and 6 and PR Mohanta for 1, 2 and 3. You don't have any role to play? Not yet received. Okay. The respondents, the council appearing for the respondents, prayed for some time to complete the instructions. Let the matter be listed after 3 weeks.
my lord, in the last part of May, my lord, that may be fixed, sir.
3 weeks, after 3 weeks, in the, after 3 weeks on a date to be fixed by the registry.
27.
Please, my lord.
Yes.
These are 27 to 33.
Hmm.
These are matters I am challenging an order of suspension.
Hmm.
These are persons who were,
Suspension, why you are, how can you challenge suspension?
my lord, what had happened here
Hmm.
was that I was granted, I was.
Suspension of what? Suspension
Of my contract.
of your contract.
So what had happened was pursuant to a tender,
Hmm.
we were the successful bidder
Hmm.
and we were operating transportation of LPG.
Hmm.
Now, as per the requirement of tender,
Hmm.
we were required to produce 2 documents.
Hmm.
One was the RC
Hmm.
and the other one was a PESO license.
What is that?
This PESO license is explosive license,
The PESO license, okay.
PESO license and
PESO
the
license.
RC.
Hmm.
Now what happened was.
So
this
these
was
2 documents you require for your vehicles.
for your vehicle.
Yeah.
Now, there were 2 categories of vehicles under a tender. One was the self-owned vehicles, which were my own vehicles, which I put under tender. And another category of vehicles were agreement to sell vehicles, which was called the ATS. Now, what happened under the ATS was that an existing contractor, somebody who was existing operations under the earlier tender, could exit the entire process, entire business.
Because he was not successful.
No, a successful contractor under an earlier tender.
Correct. So this time he is not successful.
Either he is not successful
Or he is not
interested.
Correct.
He agrees to transfer his vehicles
To you.
to a bidder under a new contract.
Who is successful in the
Who is
individual?
successful.
Correct.
Now, the requirement was that once you have entered into an ATS agreement, you have to submit certain affidavits in terms of the tender. And within 4 months from the date of allotment of work, you will have to submit the transferred RC and the amended PESO license in the name of the purchaser.
So 4 months time is granted
So
to you.
4 months time is granted within the contract. Now this 4 months period commenced sometime in September 2025. And this was to get over on 15 January 2026.
Okay.
Now what happened was, after September 2025, that is after the work allotment happened, the existing contractor under the earlier tenders were granted extensions.
Okay.
So because of their extensions, the vehicle could not be made available for transfer of RC PESO, and these extensions continued till 31st of December 2025. So effectively, the purchaser could not get the vehicle under.
But you had some more time. It was till 15th, right? 15th of January.
Till 15th.
So after 20, 15 days you get.
We
You got.
got. So what we did is that we wrote a letter, the association which represents all these persons, wrote a letter saying that kindly extend the date of obtaining this PESO and RC by the 31st of January. Now nothing, they don't act upon this letter or email of 15th January. And in fact, subsequently we get our PESO and RC. By 31st of January 2026, all the members have PESO and RC. In the meantime, also from 1st of January, we start operating the business.
Now, without the vehicles?
Without PESO and without RC, there are loading orders issued. We start loading the LPG and we start transporting the LPG.
And they are aware of this?
The loading orders are issued by them.
So they have done, while issuing the loading order, they are aware of this?
They are aware that my PESO and my RC is awaited and I was required to upload it. Now this business continues, the operation continues. Now suddenly on 5/3/2026, they issue a show cause saying that you did not comply within that 4-month period. Therefore, we are putting you under immediate suspension. Against that, I have come before my lords. My contention was that the order of suspension was premeditated. Because since I could not complete the formality of PESO and amendment because of an action on your part, because you extended the earlier contracts. Therefore, I could not get the PESO and RC in my name. So I sought for an extension. You did not give me an extension. The period of contract commenced, but much after commencement of the period of contract, after about 2 months, you issue a show cause and you put me under immediate suspension, and therefore I am against the order of suspension. That is essentially my case.
Now, after show cause, what did you do?
I have replied to the show cause, and in fact, till date, there is no decision on the show cause. So it has today become a case of prolonged suspension. So from 5/3, I continued to remain suspended. And at the end of the day, my lord, these are essential commodities, these LPG cylinders that we are supplying. This is what we are supplying to the distributors. Distributors in turn are giving it to the consumers. So from after commencement of work, on 5/3, I am suspended abruptly. And I replied because under the show cause I was supposed to reply within 7 days. So all these petitioners have replied within that window of 7 days.
How many petitions? All individually filed petitions?
All individually 7 petitions. And in total, there are about 15 vehicles which are involved.
15? 15?
15. 15 tanker trucks. There is no affidavit till now.
So you didn't get any interim order?
No. In fact, the interim order, my lord, at that stage was rejected. The stay at that stage was rejected. If my lord has the order,
What was the ground of rejection?
my lord will come to paragraph 14. There is an order of 19/3/26. Para 14 may I read. This court is of the view that an authority which has the power to appoint and the power to terminate also has the power to suspend. An order of suspension does not assume penal character, but if it is a case of prolonged suspension, then it assumes penal character. In the case in hand, the petitioner has been placed in suspension on 5/3/26 at the time of issuance of show cause, and the petitioner has been asked to submit its reply to the show cause within the period of 7 days. As on date, the period of suspension is less than 2 weeks. That was on the day when I moved for the stay. But that suspension has continued today. The contents of the show cause notice annexed and annexure 13 to writ petition are produced. Having gone through the same, this court is not persuaded to reach a view at this juncture that the show cause notice has been issued with a closed or biased manner. In such view of the manner, the prayer for interim in the form of stay of show cause notice and order of suspension is called for at this stage. And notice was issued.
So that is your case?
That is the case.
Now, why have not you disposed of his? I've received this. Yes. No, you just tell me.
Petitioner has not suffered any violation of any or any because the right to grant had exceeded the timeline of the entire tender out of utmost stating that if you are providing me trucks which are under separate tender, we are giving you 4 months beyond the date of tender. Now the work order is also issued. The LOA, the 4 months after the LOA comes to an end on 15th of January. Now the petitioner's case is that the earlier contract was extended. The early contract was extended at the consent of the petitioner. So the petitioner has chose to avail his rights under that tender and now has come back and challenged the action of the IUC. Now the maintainability of the petitioner in this petition is two terms. Firstly, the petitioner has not challenged the clause in the tender under which we are taking the show cause. We have not gone beyond the technical of the tender. We have challenged the action of the petitioner, not fulfilling the terms of the tender under the terms of clearance. Now the petitioner has not challenged that clause. That is the first issue. Second reason is that when the show cause was issued, there was no ground taken by the petitioner by the respondent IUCL, but then as yet. Cause of action has not arisen. Now those two grounds they taken into consideration.
But you have not disposed of his show cause notice. Let him respond to this.
Madam, I am only requesting that let them decide on the show cause in a time bound manner, say
Yes,
next 2 weeks from today. That will-
No, I'm not aware of that. I mean, like, I'm not concerned with this. You dispose of the show cause notices. I replied to show cause notices. Because see, there is nothing in this matter. I mean, if you have a right, you have a right. If you do not have a right, you don't have a right. Correct. So you just need to tell them that I have a right. And if you do not have a right, you'll have to give a reason why you have done it. You pass a reason order. That will do. I think that is your
That's what
grievance.
my request is.
That is
that
request.
In a time bound manner, let them pass an order.
How much time? 2 weeks. 2 weeks time. 2 weeks time. So I'll pass the order. I'll not write it here. Or should I pass it here? It will be detailed. I mean, it will take some time anyway. 131.
May I just give a few dates so that it's convenient for me?
1 second. 131 is what? 131 is
The addendum.
The second last paragraph.
the in case bidder fails to. Okay, with this.
May I give a 1-page note? It has the entire.
Yeah,
candidate gist.
dates are there.
Yes, the dates as well as the page numbers are. Maharaj, my only request would be if,
Yes.
my only request would be that if the decision is against me, if they decide to terminate, then I may be protected for 1 week from the.
No, that cannot give it. You can come immediately. You be ready.
But-
See, good counsel is always ready with the thing. So you'll have to be ready
Bharat, my
immediately.
entire-
You'll have to see all the, I mean, you'll have to foresee all the consequences.
Because Bharat, my case is that this is premeditated. The show cause itself is premeditated. So eventually
See,
it's like,
this court is not going to all those merits, huh? Mr. Talukdar, at this stage, I'm not going to all
I'm-
those merits. I
I'm-
mean, because thing is that a coordinate bench has already denied you the thing.
I'm aware.
Yeah,
I'm
after
aware.
hearing you in
I'm-
details, a very detailed order has been passed.
I'm aware.
So for that, I cannot do anything. So what I can do is like, I can give you this relief that they decide this
Within a period of 2 weeks.
within a period of 2 weeks. Okay, you write their names. We'll dispose of this matter with the direction.
All of them, 27 to 33.
27 to 20. So 2 weeks time will be granted. So you'll have to pass it. We'll have to, and you give a speaking order, correct? Whatever you do. Okay.
I'm responding.
SS Roy for respondent number 1. You just make a note and keep it here. When dictation is given, so it is ending.
I'm the. I'm.
ये नाम कितना लिखे रखे भाई?
Permission.
Only pass over the matter for time being lordship. Senior is on legs in another court lordship.
Which court your senior is there?
Court number 19
Hmm?
lordship. 19 lordship.
Court, who is your senior?
T. Som.
Here, I have taken consent from them. Let the matter come after 2 weeks. Yeah, I have taken consent.
No, why you are not doing this matter for last 4 to 5 occasions.
Lordship may fix it
No, no, no. Why for 4 or 5 occasions after filing the petition you are not doing the case? I mean, other sides, you have taken 4 times, 4 or 5 times you have taken.
So, Lordship may take up otherwise. Otherwise, Lordship may take up.
Yes, you do it.
Second half, Lordship.
No second up, you do it now, or else it will go up. Will go. Who is your senior? Hmm? Hmm.
After some time, Lordship.
What is the matter?
A matter is about Lordship, restoration of petitioner's license, Lordship. What has happened, Lordship, here?
What license?
This is trade license, TCNTL, trade certificate and trade license for operating a business.
Hmm.
Of, he
Okay,
was
we'll
dealing-
take it up. We'll take it up in the second half. Second half you call. Hmm. No problem. So the second half we'll take it
Yes,
up. Huh?
Lordship.
Second half we'll take it up. Take it up, second half, second half.
So sorry,
Hmm.
disturb your lordship, Milord. Item 21, Milord. There was on leg, I didn't know that the previous matters were adjourned. So it is reached and I was absent. Milord, the only prayer in item 21, Milord, that we have taken steps, Milord. And it was the government, the other side, there is no private respondents. Milord, there were 3 cases. 4112, 4115 and 4145. 4145. All these 3 matters should be taken together, Milord. That is the only prayer, Milord.
No, I mean, we have already passed.
Lordship passed up an order that-
Today the matters are not tagged.
That is why. No, I know, my lord. My prayer would have been, if I would have appeared, my prayer would have been that these 3 matters should be taken.
Similar matters.
Similar.
Okay,
Out
take
of
the,
the same-
give a
I'll
slip,
give the number,
give the numbers, we'll take it. We'll
Well-
pass an order and take it, okay?
One.
Item number 21.
1.
21.
I'm so sorry, I apologize.
21, you give the numbers, we'll
Numbers.
take it.
These 3 matters should be taken together.
No, see, like, this is not the way to do it, Mr. Sharma. I mean, I have taken his, he has just come and he has mentioned it, I have taken it. But when the matter is over, you cannot just come and like in between mention it. You'll have to wait till the court rises or before the court sitting. So like, you can't do it like when the matters are being called. So you wait for some time when the bench, at 1 o'clock when the bench, before the bench rises, you can mention it. Or else you can send some junior, he will do it. Before rising of the bench, you can mention it, but not in between. In between, I mean, difficult. Right? You can send somebody, your junior, any junior you can send. Okay, I'll just come back in 5 minutes.
Item 56, very early.
Heard Mr. S.S. Ahmed, the learned counsel, APP for the accused applicants. Also heard Mr. B. Sharma, the learned APP for the state. Scan copies of the TCR is awaited. Let the matter be listed. When do you want it?
Next week, 5, 6 or 7, if possible.
Let the matter fix on fixed. Next week, this banks will not be available. So it will go. Go to 19th.
Yeah.
Let the matter be fixed on 19th.
April 35.
Pays the lordship. I'm obeying for the petitioner. Lordship, we need further time to file the rejoinder, lordship.
On the prayer of the learned counsel, appearing for the petitioner, which is not objected by the other side, let the matter be listed after 3 weeks. This is last time, you file your rejoinder. Take his name.
Much obliged.
My lord, as per my lord, Lozima report dated 25 to 26, my lord. As per notice of my son, 5 to 9, my lord, deemed to be served.
All others are completed.
Let the matter will come for annexation.
As per the Lozima proceeding dated 25/2026, service is complete in the instant case. Let the matter be listed for admission in usual course. Mr. A. Khanekar is present for the petitioner. And 7 and 9, so Ms. So 7 and 9 present.
Declare.
Seven.
Yeah, please, Lordship. Lordship, notice upon the respond number 4 has been served, Lordship.
Now service, you are appealing for respondent 4. No, fine, but now it is complete, you file your whatever you want to file, okay? Yes, parties are duly represented, service is complete in the matter as per the Lwazima proceeding dated 22/2026. Let the matter be listed for admission in usual course.
Obliged.
May it please the Lordship. Lordship, inadvertently, I missed out, there was an interim in item 34 and 35.
Okay, interim order
Please
was.
continue.
Interim order extend করবে।
Here, my lord, impediment petition, my lord, service has been completed to the private respondent 7, 8, and 9, my lord.
It has already been recorded. I don't know why
Yes, my lord.
parties are duly represented. Service is complete in the instant case. Let the matter be listed for admission in the initial course.
There's an impediment petition, actually, the service regarding the.
In the IA order has been passed.
Yes, my lord.
So are you filing any objection in this matter? So you file it.
7, 8, 9, 4, maybe no one appeared, my lord, perhaps. Although service has been completed, my lord.
7, 8, and 9. You are
Nine.
appealing for whom? You are for 6.
6, my lord.
No, you write, Mr. So-and-so is for present for respondent number 6. None appeared for 7, 8, and 9. Usual course.
Admission hearing, my lord.
39.
Lordship, this matter has become infructuous, Lordship. Lordship may see kindly see page 25, the prayer portion, para B. Para B.
Page
25, para B. Writ of mandamus or any other appropriate writ as prayed for shall not be issued to the railway respondents, directing to circulate the list of elected office bearers of petitioners association.
that has been done.
That has been done
Hmm.
by this letter, Lordship. This letter.
Okay, no, not
This
required,
may
not
be kept
required.
on record, Lordship, and matter may be.
Not required, not required. You are Mr.
G.J. Sharma, Lordship.
GG, heard Mr. GG Sharma, the learned counsel, appearing for the petition. He submits that the matter has become infructuous as the relief sought for in the instant petition has already been received by the petitioner. The matter is dismissed as infructuous.
40.
May I please, your lordship, the service has been completed upon the respond number 8 and 11 as per Lozima court order at 7/4/2026. 7/4/2026 as per Lozima court order.
Yes,
The
8,
service-
8 and 11.
8 and 11. Matter may be fixed.
So
to-
others are also complete?
Also complete. Earlier order, my lord. Already.
Heard Mr.
Eke Hanan, my lord.
A.K. Hanan, the learned counsel, appealing for the petitioner. As per Lwazima court proceeding dated 7/4/2026, service on respondent number 8 and 11 are completed. Let the matter be listed for admission in usual course.
Earlier.
42.
It is your lordship.
One second, no?
My lord.
Yes, you have the instructions. Who's appealing for us? Yes, respondent number 2 only. But you are supposed to give us this whether the compensation is paid or not. No, whether it has been done or not. Why it should be kept pending for this? But you appeared, what wakalat nama? You appeared. No, we have appeared for so many occasions. Now you are saying that you will file wakalat nama. What is this? The joint verification was done on 2011-2024, right? Okay, I heard, Mr.
Verification has to be done after your lordship's order, my lord.
Now, joint verification was already done.
But after your lordship's order.
No, that is only for, I mean, if there is any compensation, that was the instruction sought for. So they are saying that like now the joint verification has been done and land is not acquired. So there is no question of compensation. They want to bring all these things on record.
Let them bring on record.
Let them do it. Heard Mr.
Dekalita.
Huh?
Dekalita.
Also, inside the learned counsel appearing for the petitioner. Also heard Mr. Richard. Also, for respondent number 2. Respondent number 2. He submits that the learned counsel submits that he has certain instructions. He has received certain instructions in the matter, and he would like to file an affidavit in the instant case to bring on record the aforesaid instructions. He prays for 2 weeks' time. 2 weeks' time is allowed. Let the matter be listed.
Respondent number 1 also be directed to file their affidavit, my lord. They are also,
1 is not required, I think.
but they were the acquiring authority, my lord. NC is DVD acquiring authority, my lord.
Who is appearing for 1? You are not filing any affidavit? But you file an affidavit. Respondent number 1 also prays for time to file an affidavit in the instant case. And 2 weeks allowed. Okay.
Much obliged.
43 to 46.
But here in this case, the item number 43, that has been complied with, my lord. That may be closed.
43 complied with.
43 complied with.
Okay.
And the others is concerned, my lord, the remaining amount has not yet been paid.
44, 45, 46.
Yes.
Yes. What instruction is this? One second, inviting. बाकी रह किस So 320 is complied with contempt case. Yes, 320 is complied with. 98, what is your instructions? Hmm? Uh, 98, Dilip Bothra. Dilip Bothra, some amount has been released. Amount is released to the district commissioner. District commissioner, what is your instructions? Okay, it was issued only on 24/4, I think. No, when? Hmm? Yeah, 23/3. So 23/3 will cover contempt case 100, 100,
297.
297, 200, 297.
And 98.
And what about this thing? 100, case number 98. 98 there is no mention. Or 98 also you have mentioned here. So let them take instructions on this. Okay, this one you complied with.
Yes, this one complete.
Right, in item number,
40.
contempt case number 320 of 2024, 25, heard Mr. R. Islam. R. Islam, the learned counsel appearing for the petitioner, also heard Mr. S. Doctor for respondent number 1 and respondent number 2. The learned counsel appearing for the petitioner has submitted that in the instant case, the direction of the honorable, the direction of the direction of this court wide order. Which was the order? Which has been complied with? Page 10.
Yes, my lord.
Huh?
Page 10, my lord.
Order dated 22/5/2024 has been complied with. Full stop. In view of the aforesaid submission, this instant contempt case is closed and disposed of. Right? And these other three you write that other three you read that learned counsel appearing for the respondent number 2, respondent number 1 has submitted a communication dated 24/4/2026 issued by the Undersecretary, Government of Assam Revenue and DM Department, which reveals that the Revenue and DM Department has released a fund amounting to rupees 900. What is that amount written? 900.905. $900.90562 lakh to the District Commissioner South Salmara Mankachar for clearing GR flood liabilities of the contempt petitioners of the year of the financial year FY 2016-17 wide letter ECF number 514532/1071 dated 23/3/2026. The communication dated 24/4/2026 along with the aforesaid letter dated 23/3/2026 are placed on record, which is kept on record by marking X. The learned counsel appearing for the respondent number 2 prays for some time to complete his instructions as far as release of the amount by the respondent number 2 to the petitioner. 2 weeks time is granted. 3 weeks time granted to the respondent to complete his instructions. Full stop. Let the matter be listed after 3 weeks. All the cases same order will go.
Same.
This one you can only keep it here. Huh?
Possible my lord, the date may be given. My lord.
Let them come up. Let
Yes.
them come.
Mat.
But in this case, my lord, in all the three cases, my lord,
48 to 50.
50, yes.
Yes,
In
yes.
all these three cases, we submitted our amended cost title.
Okay.
Thereafter, we took steps for the service of notice, my lord. But in last judicial order, my lord,
it was not reflected that notice should go. Therefore, the registry, there is a order from the registry.
To verify it.
No, my lord.
Like by registry to verify, no notice, nothing in this regard. Or registry to verify and do the needful.
Then, my lord,
That was the last order.
yes, no, did kindly see 27 March order of the registry, my lord.
Okay. Yes, 27 March, yes. It may mention that fresh text was on the one has been received, however, there is no order for fresh issuance of notice, neither upon the newly included respondent nor remaining respondents.
So, my lord, steps has already been taken. So, my lord, now order from your lordship is required to send this notice, my lord. The fresh notice, my lord.
Okay, 9-3 order, there was no order passed for
For
issuance
issuance
notice.
of the fresh steps. But we took the steps after
Okay.
the amended cost title,
Mm.
because the incumbent has changed.
Mm.
That is why we submitted amended cost title.
Yes. Heard Mr. H. Omo, the learned counsel appearing for the petitioner. He submits that amended cost title in the instant case has already been filed, and steps for service of notice on the new incumbents have already been taken by him. However, since there was no order no order for allowing taking of press notice is issued, the registry could not send the aforesaid notices to the respective incumbents. Full stop. In view of the aforesaid factual situation, let notice be let fresh steps be taken for service of notice, which has already been taken by the petitioner. Let registry to send the notices to the respective incumbents, and let the matter be listed after 3 weeks.
My lord.
51. Maybe. You can notice the issue, the contempt proceeding, but neither they have filed any.
27-3 you have issued notice, no?
Yes.
So we'll wait for some time.
And my lord, there is.
Wait for Mr. Heard Mr. A. Rashid, the learned counsel for the petitioner. Let the matter be listed after 2 weeks. 2 weeks.
Date may kindly fix, otherwise.
2 weeks, no contempt matter. Notice may come, then we'll fix a date for you.
First. 52.
None appeared for the petitioner when the matter was called for. Let the matter be listed after 2 weeks.
May please, your lordship. Service of notice upon the respondent number 4 and 5 has already been taken, lordship. As per office note dated 1/4
Okay, heard Mr.
MS Mondal, lordship.
MS
Mondal.
Mandal for the petitioner. Also, Mr. S.K. Hazarika for as one number 2. Office note dated 1/4/2026 reveals that service on respondent 4 and 5 deemed to be completed. Let the matter be listed for admission in usual course.
Obliged, lordship.
সেইটো কেছত ডেটটা দি দিয়ক হেৰি কি কয় ফাৰ্ষ্ট উইক অফ মে'ত ডেটটা দি দিয়ক এই যোনটো কেছ টিচমৰ কেছ ক'ব যে এতিয়া মেটাৰ নাই গতিকে আমি ডেটটা দি দিছোঁ ফাৰ্ষ্ট উইক কোনটো হেৰি দি দিয়ক সেইটো লগত কেঞ্চেল কৰি লওক নহ'লে কৰি পিনে এটা ডেট দি দিয়ক টিচমৰ হেৰি বৰা আৰু কোনোবা আছিল নে এটা কনভিনিয়েণ্ট ডেট ফাৰ্ষ্ট উইক অফ মে'ত
No, no written on. Okay. What service? Let this matter be listed on. Only date with everything.
contact করবো লাগবে all contact করবো লাগবে item ধরিব লাগিব কি হেৰি কৰিব নে সময় একবাৰ মোৰ সেকেন্ডত আছে কম্পিউটাৰ এটা দিব দিছে টাইপ কৰি দিম সুধি দি কিনে দিব এনেকে দিলো Rather comes the limits fees from this step to contact the item number 54. The 22.